Today, we're focusing on a really sensitive issue emerging from Ethiopia. Reports of a potential ministerial decree that would ban Muslim students from wearing the hijab and performing salat, or prayer, during school hours.
And the central question really is this: does the state's interest in a uniform secular educational space justify these kinds of restrictions, especially when they seem to clash with Ethiopia's own constitution and international human rights law?
Exactly. My position is that this policy, if it's implemented, would be a form of unlawful, indirect discrimination. It just fails the crucial legal tests of proportionality and necessity.
And I'll be arguing that while these rights are fundamental, we have to look at this from the state's perspective. The source material points to recurring conflicts, these, regional and institutional incidents that have become flashpoints. So I think the state may have what it sees as a necessary justification to apply limitations that are in fact permitted by the Constitution to protect public order in education.
Okay, so let's look closely at that standard, because the legal hurdle here is exceptionally high. The FDRE Constitution, in Article 27, it guarantees the right to manifest religion in observance, practice, and teaching. And crucially, it only allows for limitations that are, quote, prescribed by law and necessary to protect public safety, health, education, public morality, or the rights and freedoms of others. So when we look at a blanket prohibition on two core religious practices, the hijab and prayer, the government has this enormous burden of proof. A blanket ban is the most restrictive tool you can use. It suggests no thought was given to less intrusive alternatives. The state is legally obligated to at least explore reasonable accommodations, things like scheduling brief prayer breaks or modifying school uniforms to allow a headscarf. By forcing students into a choice between faith and schooling, the rule doesn't just violate freedom of religion under the ICCPR, but it also contravenes the right to education itself.
I agree that proportionality is the legal acid test here. And it's a standard the state seems, reluctant to publicly engage with, given the lack of transparency around the decree. But I want to focus on the institutional history that the material mentions. These conflicts over the niqab, the hijab, salat, they aren't new. They're described as local disputes that have led to repeated protests and court actions. So if you have regional bans like the ones mentioned in Axum already causing all this administrative and judicial pushback, the ministry might see a national directive as the only way to solve this pervasive religious friction. The argument from their side would be that this regional volatility is undermining education as a functional, uniform system, and that this restrictive standard is necessary to, restore neutrality and stop the system from fragmenting even further.
But that perspective, the one that prioritizes administrative convenience over fundamental rights, it just collapses when you look at the demographic impact. This measure results in what is clearly indirect discrimination. When you target a community that makes up, 31 to 34% of the country, we're talking about around 43 million people. The standard for necessity becomes almost impossible to meet without showing that every single less restrictive measure has been tried and has failed. You mentioned administrative difficulty, but is it really impossible to designate a quiet space for a 5-minute prayer break? Or is it simply that the central government has decided uniformity is cheaper than accommodation? That doesn't meet the least restrictive mandate required by human rights law.
I'm not sure the issue is just about convenience or cost. We're talking about a nationally scaled public education system in a highly decentralized federation that is grappling with immense diversity and, a history of localized power struggles. So while you can propose these elegant solutions like modified uniform policies or prayer breaks, the central authority might genuinely see that as administratively unworkable. Mandating reasonable accommodations across thousands of institutions that have already struggled with local contradictions could, in their view, lead to more fragmentation, more conflict. This isn't an ideal system with robust, unified judicial enforcement. It's an environment where local governance issues become political flashpoints. The state could argue that removing all visible religious markers is the only effective last resort measure to manage that friction.
But how do you justify that? How are the rights and freedoms of others protected by singling out the practices of just one faith? You brought up the limitation clause. public morality and rights and freedoms of others? How does a student wearing a headscarf or quietly praying during a break violate public morality in a constitutionally multi-religious state? That's where the justification just falls apart. A regulation that specifically targets the hijab and salat is by its very nature not religiously neutral. The moment the state says these specific practices disrupt a religiously neutral environment, they're signaling that one faith is fine and another needs to be prohibited. That is the definition of discriminatory impact, whatever the intent.
But the legal justification they might use is framed around institutional neutrality. This idea that the shared educational space has to be free from what they perceive as, well, as religious proselytization or visible segregation that might inflame existing ethnic or religious fault lines. They're trying to standardize the look of secular education. And while I agree, yes, this has a clear disparate impact, we have to understand that the state might see this prohibition as the last tool available to achieve what they see as a legitimate aim, a school environment that is neutral and accessible to all students, especially in regions where religious identity has fueled political tension.
It's an inherently flawed argument, though, because you're essentially asking us to accept that the only path to equality is through suppression. If the goal really is neutrality, the measure must be justified as the least restrictive means. And history, whether it's France or Turkey, shows us that blanket bans on religious dress carry massive social costs. They often fail the necessity test precisely because reasonable accommodations were available. For example, in other federal systems, schools successfully use a uniform template that allows for variations in headwear, provided the color and fabric match the school standard. It maintains uniformity without suppressing identity. The Ethiopian ministry has to show why that common, less restrictive solution is completely unworkable nationwide. Until they do, the disparate impact stands as unlawful discrimination.
Okay, so we're clearly in tension here over the feasibility of nationwide accommodation versus this institutional desire for rigid uniformity. Let's pivot then to the consequence, the right to education. I acknowledge the policy creates a disparate impact, but I have to question whether the source material overstates the outright denial of the right to education. The state's aim is a secular education system, which is a legitimate institutional goal. Is a requirement to follow a restrictive dress code really the same as a complete denial of access? Or is it a condition placed upon attending a state-run secular institution?
But that distinction, it falls apart when you look at the functional reality for the student. The rule absolutely can and does amount to a denial of education if it creates, quote, de facto barriers to attendance. Think about the student who's suspended or excluded or just repeatedly sent home for adhering to her faith. That isn't just a condition of attendance, it's constructive exclusion. The constitutional ecosystem in Ethiopia is designed to protect minority rights and religious practice. International human rights bodies consistently warn states against rules that force a student to choose between a deeply held religious identity and their right to schooling. When a rule forces that impossible choice, it becomes functionally discriminatory and violates the state's core obligation to ensure access.
I understand that point, and the potential for exclusion is, without a doubt, the most serious consequence here. I would, however, frame the state's logic differently. When the state asserts its right to mandate secularism, it's essentially arguing that when a conflict arises between two constitutional values, the right to manifest religion and the obligation to provide neutral education, the manifestation part has to yield when it enters the public institutional space. For them to avoid the charge of denying education, they would need to prove that the system couldn't function otherwise. They are claiming a necessity that, in their view, overrides the conditionality argument.
A necessity that has yet to be proven, and the social costs of making that assumption are profound. Which brings us right to the social compact, maybe the most practical concern in the material. Ethiopia is a multi-religious, multi-ethnic federation. Its delicate stability is always relied on respecting diverse practices. So singling out the practices of the Muslim community, a huge, historically foundational community, risks inflaming intercommunal tensions and magnifying regional grievances, especially when we know this tension has already played out unevenly across regions. A heavy-handed national rule could undermine the country's fragile social stability.
I don't entirely disagree, and I concede the danger of social instability is real, but let me offer a counter-framing of the ministry's motive. The tension you're describing has been made worse precisely because of the existing legal fragmentation, these inconsistent local bans, these varying interpretations. It's plausible that the ministry sees this national decree, however flawed and restrictive, as an attempt to establish a single, clear norm to stabilize the system. They might see it as preventative medicine against the deeper regional fragmentation caused by this uneven, localized enforcement. They're trying to solve the problem of local flashpoints by removing the point of contention at a national level.
But by trying to suppress a flashpoint, you're just moving the friction from the local school to the national government, and you're magnifying the conflict. The whole constitutional design of Ethiopia is meant to manage difference, not eliminate it. A national ban is going to create a situation where Muslim-majority regions feel targeted, while other regions might not even see the need for it. That's the very definition of magnifying regional grievances. The only path to legitimacy, even for a rule like this, is through transparent rulemaking and real engagement with the affected communities.
And that is the essential prerequisite, which I think we both agree on. The state must publish the legal basis for this and show that they've done the proportionality calculus. My argument is just that in a fragile system where local contradictions have repeatedly destabilized institutions, the state's focus on uniformity, while restrictive, probably emerges from a credible institutional concern over systemic failure, even if it, grossly misunderstands its constitutional obligations on accommodation.
So to summarize my position, based on Ethiopia's own binding legal texts, Article 27 of its constitution, Article 18 of the ICCPR, any blanket policy banning the hijab or prayer in schools will likely fail legal scrutiny. The policy is a form of unlawful indirect discrimination, and it lacks proportionality because the state has failed to even explore less intrusive, accommodation-based measures. The only constitutionally valid standard is reasonable accommodation, not outright prohibition.
I'll reiterate that while this proposed rule appears legally flawed against those standards, the state's perspective is grappling with a real history of flashpoints and local contradictions. The debate really highlights this difficult balance between protecting fundamental rights and the state's claimed interest in establishing a uniform, secular public order to manage institutional friction. The state's necessity argument is extremely weak without a public justification, but understanding that underlying rationale is vital to analyzing the crisis.
Absolutely, and the crucial next step, which we both agree on, is that the ministry must publish the full legal basis for any decree and subject it to a rigorous, transparent proportionality test. They need to explain why less restrictive accommodations are definitively insufficient.
Right. And considering these conflicting pressures really deepens our understanding of constitutional rights, especially the limits of state power versus minority protections within a multi-religious federation like Ethiopia. There's clearly much more in the material to analyze here.